Okay. Okay. Good evening, everybody. It is a little after 6:35. Welcome to our workers' comp training. For those of you who don't know me, I'm Steve Tully. I'm the executive director of AFSCME New Jersey Council 63. Twice a year, we do this training because although it doesn't fall under the umbrella of traditional union representation, we all know that we have workers who get hurt on the job. There are a lot of questions that you have. There's a lot of information that you need to know, that your members need to know. But workers' comp, as I've discovered over my fairly lengthy career, is a whole other world. So we want to do this training to give you information that that you need, and to have somebody who knows what they're talking about and can break down workers' comp and can give you all the information that you need. So that's why we do this training. But before we begin, I do just want to take a moment to wish everybody for tomorrow a happy Veterans Day, and to say thank you to all the veterans out there. Thank you for your service to our country, and thank you for keeping us safe throughout all of these years as a country. During the course of the training, I would ask that you please type in your questions in the chat box. Our presenter will be looking at the chat box, and we'll get to the questions during the course of the evening. For those of you who have been with us before on trainings, if we don't get to a question in the chat box during the training, we follow up with emails after to answer questions as best we can. Okay, so keep that in mind as we move forward. This training is being recorded, so tomorrow we will send out a copy of the recording to everybody, along with the PowerPoint, although we sent that to everybody earlier tonight, or this afternoon, I guess. Okay. So with that, let me introduce to you our presenter for the evening, our attorney that we always go to when we have workers' comp cases, workers' comp questions. When our members get hurt on the job, this is the guy we call. He is just a great resource, very knowledgeable. The feedback we get from members from when he represents them is just phenomenal, and we're happy that he's here tonight, and quite frankly in the past as well, to always educate our members, educate me as well, and our staff about workers' comp. So let's welcome Sam Gaylord. Sam?
Thank you very much, Steve. I appreciate it.
You got it. You ready to take the controls?
I am indeed.
All right, I'll take a step back. You're on, brother.
Very good. Thank you very much. And first of all, let me just say thank you. I appreciate the opportunity to come and speak with you guys tonight. I have hopefully a bunch of great information that we're going to sort of dump on everyone. It'll sort of be the old picture of the little child with the fire hose and the water coming flying out. So if you've seen that picture before. But before I get started, I want to make sure that everybody knows that if you have any questions, either during or after or something like that, my contact information, all of my contact information is at the back of the PowerPoint presentation. And I will, when I'm done here, I will give everyone my cell phone number. So if something comes up, I'm here to help as many people as possible. Real quick background on me. For the last 26 years now, all I've done is represent injured workers. I am certified as a workers' compensation law attorney. I handle Social Security disability matters, and I litigate disability pension claims. And that is the extent of what I handle. So everything to do about anyone who gets hurt or is disabled and who is not able to work, that is in the proverbial wheelhouse. So although we're going to talk a lot about workers' comp tonight, there are pieces of that touch on the other two things. And so we'll be mentioning them as I go through that. From a global point of view, like I said, sort of a global perspective, we're going to talk about workers' comp tonight. But again, if just to give you a sense real quick, right? If somebody that gets hurt at work and then they're out of work for more than a year, they can apply for Social Security disability benefits. If somebody gets hurt at work and they are not able to return to doing their job, then they may have the opportunity to apply for a disability pension. So we're going to get to all of those things. One of the things that I like to start off with when we jump in is to sort of what I call sort of set the stage a little bit. We're going to talk about the types of work injuries that can exist. We're going to talk about the benefits that you are entitled to, or that members are entitled to when they get hurt at work, despite what the employers might tell you otherwise. And the other avenues by which someone can receive certain benefits if for some reason the employer and or the insurance carrier are denying the work-related injuries, okay? So before we get started, let's do it this way. Just for housekeeping, there are two basic ways that an individual can get injured. The first way that somebody can get hurt is that there is a specific incident, a specific accident, on date such and such, I tripped and fell and I hurt my knee, okay? You fill out an incident report and off to the races we go. So it's pretty straightforward in the sense that it's reported and everybody has knowledge about it. And then you start going through the process. And I'm going to explain the whole process. I'm just this is sort of a preemptory big picture. The other way that someone can get injured, and it is covered by workers' comp, but is often denied by the insurance companies or the employers, are what are called occupational claims. So I repetitively do this for 10 years and I get carpal tunnel syndrome. Okay, that's a covered work-related injury. It doesn't happen on a specific date, time, place, but because it is of an occupational, I repetitively do it over and over again for that period of time, I can demonstrate that that was aggravated or caused by my work effort. Therefore, it's going to come under the umbrella of workers' compensation. Okay, so those are the two basic types of ways in which someone can get injured. Now, again, the occupational, I use the carpal tunnel as an example, but it could be anything. Where my main office is in Trenton, right up the street is Ann Klein Forensic Center as an example, and there has been huge mold exposures in certain sections of the facility. That exposure over a period of time is exactly the type of occupational claim that would come under the umbrella of workers' compensation. So it doesn't have to necessarily be physical. It can be occupational in the sense of I'm exposed to mold. It can be an occupational psychiatric. I see this, that, and the other thing over an extended period of time. As a result, that causes me to develop a psychiatric condition. That can be covered under that occupational umbrella. But from a big picture, those are the two types of ways in which someone can get injured, okay? When someone, let's use the specific accident, and as I go through this tonight, please, the interaction, if somebody has questions or comments or wants to ask anything, you can definitely type it in and I'll try and go back and forth as best I can. Certainly, if there are other questions, as Stephen mentioned, I'm more than happy to answer those subsequent to tonight's presentation. But having done this in the past, it's always better when there's sort of an interaction. I will also tell you that as I go through this, I'm giving the information from a more often than not point of view. And I say that because there's no doubt about it. There are stories that somebody might have that will be contradictory to the way in which I'm trying to explain something. And I would absolutely agree that's 100% accurate, depending on where you're working, depending on who you're dealing with, depending on a whole bunch of factors. It may be that something doesn't sound the way I'm explaining it. And I would say, yes, 100%. And if it's a specific type fact scenario, that's something that I can answer separately. But when somebody gets hurt at work in the state of New Jersey, by law, you are automatically entitled to receive 3 very specific benefits. The first is medical treatment. And I'm going to go more into depth with each of these 3 things, but the first thing is medical treatment. The second thing is if you are out of work for more than 7 days, then you are eligible to receive what's called workers' compensation or temporary disability benefits. And then when you're all done with the doctors and you've returned to work, you are also eligible to receive an award, a dollar award for your injury, okay? So the first thing that I'm going to advise everyone is report the injuries, okay? Even if it doesn't seem like it's going to be a big deal, fill in the incident report. I cannot tell you how many times we get into a situation where we're meeting with a client, and even though it may only be 2 or 3 weeks later, and they're now reporting the fact that it happened at work, and they may have a witness or somebody who saw them fall or whatever, right? They didn't fill out the incident report. Now, why does that happen? Well, because it's quite frankly, it's human nature, right? If you fall in the cafeteria and everybody sees you fall, right? The first reaction is you're going to stand up, brush yourself off. I'm fine. Right. And that's because, it's embarrassing and because you want to make sure you're okay and all the other good stuff. But the reality is, if situations like that happen, the worst thing you can do is not report it. Okay. Because then what happens is the employer, the insurance company, whomever, the state, right? They're going to say, well, that was weeks ago. Why didn't you say anything? We're going to have to investigate. Meanwhile, time ticks off and the treatment's not happening and the benefits aren't coming and it becomes more complicated. So one of the first pieces of advice I would say to everyone is, even if it seems silly, even if you feel fine, no matter what, fill out the incident report. If the employer won't take the incident report, or they're like, well, we're not going to fill that out, no problem. What you do is you send a letter and you send it certified mail and you send it right to the employer or human resources, indicating that on this date, this is what happened. And by doing that, you send it certified mail, you get the green card. That way later on, nobody could say, well, you never said anything. Okay. It's all about the reporting. All right. So that's the first thing. Now, medical treatment is the very first benefit that you're entitled to receive. It's the most important thing. Typically, what will happen is that when you report the injury, they're going to send somebody to Qualinx or Concentra or, the places that I really wouldn't send my chocolate lab to get medical treatment, right? But that's part of this spiel. And the idea those doctors have, in my opinion, is, we're going to slap a Band-Aid on a bleeding wound and we're going to send you right back to work with, no real treatment because you're fine, brush it off, you're good, right? So the idea is when I start talking to people right up front after they've been injured, our idea is to try and get them as fast away from those places as fast as possible to actually go see what I would call the real doctor, which is going to be the specialist. So let's use I trip, I fall, I hurt my knee injury. So we want you to go and see an orthopedic doctor as fast as possible, right? Typically what they're going to do is they're going to send you maybe for an x-ray, maybe not. They'll send you for some physical therapy, maybe. And then at that point, they'll say, oh, you're fine, and of course they're going to send you right back to work. Doesn't matter what's going on, right? I'm sure you've experienced, you've gone through this, you sort of have a good understanding of what exactly I'm talking about. But the idea behind medical treatment is that they're responsible, whomever the other side is, they're responsible to pay for everything. So if a doctor says you need therapy, 4 weeks of therapy, that doesn't mean 3 weeks of therapy and then they stop the 4th week, right? Which happens all the time also. It means you're entitled to 4 weeks, right? If they indicate you need an x-ray or an MRI or whatever, those types of medical treatments are all furnished and paid for by the other side. You should never get a bill in the mail for medical treatment. Now, where we see clients are getting medical bills in that specific incident form is like if you go to the emergency room, sometimes they'll pay for the emergency room visit, but they won't pay the radiology bill. So you wind up getting an x-ray and then they're going to try and stick you with a bill. or you really fall and you got to get taken by ambulance to wherever they're going to take you. All right. And then the next thing you know is you're getting the ambulance bill, right? None of which are your responsibility. So, and again, if you get hurt at work, one of the most important things that you want to do, again, if you have questions, you should always talk to an attorney. Now, I say that, certainly I would appreciate if you call me, but here's the thing. You want to make sure that you're talking to someone who specializes in this area of law. So workers' compensation is like a niche. It's like a sorority, right? It is a group of lawyers who, if they do this, and they really do it, everyone knows everyone else, okay? And so I know the judges and I know the attorneys on the other side. And if you say, oh, I work for this one, I know it's Qualinks. I know who the nurse case manager is going to be. I can tell you who the attorney is going to be. And I can already send an email to the lawyer saying, listen, I'm going to be representing this person. Here's what we want. So you want to make sure that if you're talking to somebody, right, you're talking to an attorney who is a board certified, workers' compensation law attorney, right? If you have a heart problem, you're not going to go see the podiatrist, you're going to go see the cardiologist. Same rules apply, okay? But you want to do that sooner than later because I feel, everybody's got a sort of different philosophy about it, but I feel that if someone on the other side knows that you're represented, if they have someone that they know that's there, then they can't sort of roughshot and send you forms to sign without you thinking about, oh, well, okay, I'll just sign it and send it back, right? And then all of a sudden, the next thing you know, they're tiptoeing through 10 years of family medical records. That's none of their business, okay? Especially if you've fallen and hurting yourself right at work, it's none of their business what you told the doctor 5 years ago. But some of these insurance companies want to try and get access to that information. So they'll send out forms, they'll send you an authorization, they'll send you warm, fuzzy letters that say, hey, we're here to help, just let us know if you need anything. By the way, just sign this and send it back to us. So I personally think it's better that if you get hurt to get representation up front. But and sometimes we'll meet with someone and if everything's going smooth, then I'll say to somebody, look, I'm your ghost right now. So I'm behind the scenes, right? We don't have to file anything right away, but if something happens, then I have access to the state's computer, and in about 5 minutes, I can file a claim, and then they're going to know that I'm on board and that they're not going to have to deal with me. So, but if everything's going smooth and the adjuster's doing what they're supposed to do and everything's going hunky-dory, well, then we'll just stay off to the sidelines until at some point, that's not going to be a problem, okay? So the medical treatment is the most important thing. So now, if you get a bill, one of the things that we do is I will write a letter to the medical provider or whomever's sending the letter, advising them that it's a workers' compensation case and that they should stop contacting my client. Otherwise, they're going to be in violation of the Fair Debt Collection Practice Act. We send that to the insurance company to say, hey, pay the bill. And we make sure that that does not become your responsibility. Also, it does not get reported on your credit report, okay? Because again, none of that is your responsibility. So medical treatment is the first thing. It's also the most important thing, and the reason for that is because a workers' compensation case, once you go through the process and at some future point that case resolves, workers' comp in the state of New Jersey says specifically that after your case settles and you receive that award, you now have an additional 2-year window where you can reopen your case so that if your condition gets worse and you need additional medical treatment, then you can actually reopen the case. The insurance company has to send you back to a doctor, provide additional medical treatment. And if there's a worsening in your condition, then you receive additional money on top of what you received the first go around. You got to realize that most of, in my opinion, again, most of the insurance company people, right, the adjusters, the lawyers, right, there's a cynicism, right? And it cracks me up because, they think that, you get hurt at work and everybody's instantly lying. You didn't really get hurt at work, right? And, they think you're just sitting around at home, eating bonbons and watching daytime television, right? Which is ridiculous, okay? Because The reality is that a good bunch of people, when they get hurt at work, they're actually losing a ton of money. First of all, workers' compensation only pays 70% of your gross weekly wage. That's tax-free, but they pay 70% of your gross weekly wage. That's first, okay? Secondly, if you're normally making overtime and you can't do overtime, then you're only getting paid the 70%. Now, the 70% is also capped. So every year, there's a cap in terms of how much money per week somebody can get paid. So I'll do an easy math example. If my gross weekly wage is $1,000, workers' comp is going to pay me $700 a week. Okay. However, if my gross weekly wage is $2,000 a week, I don't get paid $1,400. The maximum in the year of 2022 is $1,065. So I'm not getting 70%. I'm getting less than 70%. So, and there's no makeup to that. In other words, there's no, when you get hurt at work, there's no award for lost wages. They don't provide that to you. Okay. So, so it cracks me up when I listen to the cynicism behind the other side when I do this all the time, is that my clients want to go back to work. They want to get better. They don't want to wait 4 weeks to get authorization to go get physical therapy that the doctor recommended 4 weeks ago, and then they go for 2 visits because the adjuster took 3 weeks to authorize the medical treatment that they should have been getting 3 weeks ago. Okay, so they want to go back to work and they want to get better. They don't want to be sitting at home. All right, but it's just such a slanted view that they have that, again, anybody who gets hurt, they must be lying, and that's just the way we deal with it. But the temporary disability benefit, that workers' compensation benefit, all right, that you get paid 70%, and you get that as long as 2 things are happening. One, the doctor is indicating that you are out of work, or the doctor says light duty, but wherever you're working, there is no such thing as light duty, so you get paid the workers' comp. And 2, the doctor is indicating that you need additional treatment to get better. And as long as you have both things, then you're going to continue to receive that workers' comp benefit. Now, one of the things that I hear quite a bit all over the place is that, oh, it's only, I can only get workers' comp for 6 months, or I can only get workers' comp for a year, or something like that. It's actually absolutely not true. It's not true. The answer is that if you can actually get paid temporary disability workers' compensation benefits up to 400 weeks. So it's actually under the statute, under the law, you can actually almost get paid for being out of work up to 8 years. But I hear it all the time is that, oh, well, the HR told me it's this and they told me it was that. It's absolutely not true. Under the workers' comp statute, you get paid can get paid up to 400 weeks of being out. One of the questions we have here is, if somebody's coming off of break, is that covered by workers' comp if they slip and fall? The answer is yes, that is covered by workers' comp. If you are on the, let's say, on the premises and you're taking a break, going to the bathroom or taking a lunch break or whatever, and you're coming back and you slip and fall, yes, that would be covered by workers' compensation and the benefits you'd be entitled to receive. Interestingly enough, that, because you hadn't actually gotten back to work, might be something that a pension situation might deny, but for workers' comp and what we're discussing here, yes, that would in fact be covered by the workers' comp system. The person taking vacation, sick, come back to work, they say you have to pay it back. Good question. So the question is one about if you're out of work getting paid workers' compensation, and then when you come back to work and somebody, because you were out for a period of time, they use sick or vacation and then they prorate it. So now they say or claim that you've been overpaid or you used too much time because you were out on workers' comp. Yeah, those are very, I would say, very fact sensitive. And if you had a specific issue on that, the sick or vacation time, we could definitely discuss that. No, does the length of time you've been employed determine how much you could take for workers' comp? Absolutely not. It doesn't matter. You could be your very first day on the job And if you slip and fall, you're still covered by workers' comp. You're still entitled to all of the benefits. Now, one of the best things that I like talking about when we are talking about the temporary disability benefit, and this is one that I've said it before in these presentations, but I think a lot of people don't know, and this is sort of one of the really things that you want to shout from the mountaintops. When somebody is out on workers' compensation, if you are a member of the public employees, police and fire, teachers, whatever, you are, or I should say, the employer is required to make your pension contributions for you. So if you're getting paid workers' compensation and you're out of work for 6 months, that 6-month period of time, your pension contributions, your time should not slow down. That contribution, that 6-month period, has to be paid by the employer directly to pensions. So one of the things that we do is when someone returns to work, I send a letter to the Division of Pensions and I indicate my client has been out of work from point A to point B. And then we make sure that pensions receives the money from the employer. Best part is if they don't, pensions becomes your collection agent. Pensions and their audit department will actually write to your employer to make sure that the employer makes the pension contributions for you. So that is one of those things that people don't know. There are certain employers I deal with all the time that constantly won't make these contributions, and we are constantly banging away at human resources and client forensic center. I know it's just the top of my head is one of the worst. They choose just not to do it. So, okay, who determines if you get the 70% pay? My employer says they determine if workers' comp or if you're using personal time. Okay, so one of the things that comes up, and again, depending on where you work, is that the employer might say to you, hey, you can get paid workers' compensation, which is the 70% cap, or you can do that, and we can also then use your time on top of that. So it sort of mounts up as if you're getting paid your regular thing, but they're using some of your time. So that's a decision you sort of have to make on your own, what you want to do for the situation. Now, that's not every employer. That certain employers offer that sort of combination. They don't have to. If you're hurt, you're out of work, you're covered. Now, under contract, some employers will do it in such a way where you will get paid your full wage for a period of time. And then once that's over, it comes down to just the straight out workers' compensation. Do you have to pay your employer, right? So the workers' comp, the temporary disability payment when you're out of work, that's yours. You don't have to pay that back. Those are your benefits. So so that's how that plays out. So the way we cut up a workers' compensation case is sort of into two different pieces, right? You have the medical treatment and you're out of work piece. And then that goes until the doctor says, okay, at this point, I believe you've reached that sort of maximum medical improvement, all right, or MMI as they call it. And then once that happens, then the next mechanical part of a case is we'll grab all of the medical records. We will then send someone to see our doctor for an evaluation, and then we'll move forward to try and resolve the case, which is the third benefit that you're entitled to. You're entitled to receive a money award for your injury. Sick time, right? Okay. So now let's talk about, so when we talk about a workers' comp case, our slip and fall, there are no issues. Medical treatment, you're going to get paid temporary disability, and then you're entitled to receive an award for your injury. Now, again, remember, all of the benefits that you receive from workers' comp are tax-free, so you're not paying taxes on those dollars, okay? And again, as we talked about, especially for the time that you're out of work, to always remember that that is the employer's responsibility to make those pension contributions for you. All right. Now, The next thing that we want to talk about are some of the, if this is a situation where the employer or the insurance company, they're going to deny the case. Okay. So let's go with our carpal tunnel case, right? We're doing data entry, we get carpal tunnel, and we say, hey, I think this is work related. And of course, the employer or the insurance company say, you're full of baloney. It's not covered by workers' comp. Use your own insurance, right? And so the question then becomes, what direction do I go in? How do I work that? What do I do? Well, the first thing is, quite frankly, as far as I'm concerned, especially if you have access to health insurance, the best thing is that you want to have them deny the case. Because if the insurance company denies the case, or if it's the state or whomever, if they deny the case, now you are free to go and see a doctor of your choosing, because now you're able to use your insurance. Now, yes, you're going to have co-pays and other, things that you're going to have to pay for. But I will tell you, you keep track of all those things. You keep those receipts, because when it comes time to settling the case, we can get money reimbursed for those out-of-pocket medical expenses. But if they deny the case, you now are free to use your insurance and go see any doctor that you want to go and see, which has got huge advantages. Remember, when you're in workers' comp, although they're paying all the bills, they are telling you where to go. All right. Now, there are certain doctors, again, you do this long enough, and there are certain doctors who, are of the ilk that they're going to do whatever the insurance company tells them to do. And then there are other doctors who are unwilling to sort of be swayed by that, and they will provide real medical treatment for those people. So we know who the doctors are who, and again, if you know that somebody is seeing somebody, the doctor's going to brush them off, then we're asking for a second opinion. We're trying to get somebody evaluated by a doctor of ours who's a treating doctor to combat somebody who's going to make reference to, oh, you don't need any more treatment, you're fine. So we're always paying attention to who's seeing whom, so we have a good sense of, are you going to get the right amount of treatment? Are you going to get the right treatment as fast as you can? That's really upfront. That's the big trick to it. But if they deny the case, there's an advantage, because again, you get to go and see your own doctor. Disadvantage, if you're out of work, okay, how am I going to get paid, right? Well, again, depending on where you are, is there a short-term disability policy? Is there a long-term disability policy? Do you have your own disability policy? Do you apply for state temporary disability benefits? All of which are dollars that you may have access to in order to provide dollars while you're out of work. Now, again, depending on, again, in this denied scenario, it depends on how long you may or may not be out of work. So if somebody's going to get treatment and they're going to only be out of work for 4 to 6 weeks, it's not nearly as crucial to try and get it thrown into workers' comp and covered, because that person's not going to be out too long. They'll be able to get the medical treatment they want as quickly as they want, see the doctors they want to see, and then we'll go fight about who's responsible later on. The best part is that most of if you're using your own insurance and you work for the state, or if it's Horizon Blue Cross Blue Shield, right, they're not going to bother to sue themselves to try and get their money back. So you don't have to worry about later on, oh, my insurance is going to come after me, or my insurance is going to go after workers' comp. We would take care of all that. So that way, when the case resolves at some future point, right, we're covering all of those issues. Nobody, after we're done with a case, is going to get a letter that says, oh, by the way, you settled your case, but you owe us $5,000 for medical expenses. Doesn't work that way. Okay. Well, I make sure it doesn't work that way. All right. But again, in the denied case, if you're going to be out, you have access to state disability, a private plan. There's ways in which you can receive dollars. Now, again, later on, when we resolve the case, we argue that you should have gotten workers' comp for that period of time. So again, what I'm arguing for is not only to make sure that it's not that your time gets reimbursed, but that you get back credit for the time that they took first. Second, if you're out or were supposed to be out getting paid workers' compensation and had to use either state disability or your own time, then again, those pension contributions have to be made. All right. So one of the things that I always sort of am looking at when we're going through either workers' comp or some of the others, some of the other benefits that we talked about, Social Security and pensions, is I'll sort of describe it as playing three-dimensional chess. I'm not just looking at this move, I'm 4 moves ahead, knowing what's going to happen between then and now. So it's always important to just keep it ahead of the way in which they being the insurance side, is going to try and, sort of manipulate through the system. Now, if somebody is out of work, right, there are going to be some other things that are going to crop up. First of all, if you're out of work for more than, the first 12 weeks, you're covered by family medical leave. Okay, as long as you have worked more than 1,250 hours, as long as there's more than 50 employees, you're going to get covered by family leave. Now, that's important because under family medical leave, you get the 12 weeks, job protection, plus you only have to make your insurance, your health insurance contributions rather than, COBRA payments, things of that nature. Now, a lot of my clients, members of AFSCME, have greater protections by way of the contracts, but if, let's say you work for ABC company and after the 12 weeks, you're still out on workers' comp, legally, the employer doesn't have to keep you, because once the FMLA runs out, even though you got hurt at work, workers' compensation does not provide additional job protection. So a lot of our clients, a lot of AFSCME members have greater protections because of, the union contracts and things like that, where that can't happen. But how many times have I seen where somebody's out on workers' compensation, employer wants to try and get rid of them. So instead of doing that, what they do is they file a preliminary notice of discipline saying, oh, well, you can't perform your job, so we're going to file a disciplinary action. And then I got to go to a disciplinary hearing and sit with somebody telling them, look, they're covered by workers' comp. This is ridiculous. What are we doing? But it's their way to try and force somebody out. So then you have to go through that process. And again, depending on the severity of how somebody is injured, it would dictate whether or not we're going to move in a pension direction. And if that's the case, now you're talking about how those two things are going to work. But there's plenty of times where I see employers are trying to get rid of people. So they'll do it by way of the discipline. The human resources all of a sudden start getting ticky-tacky with, oh, well, this, that, and the other thing. Or quite frankly, they're just going to basically say, again, if you're out for a year, how many times have you guys seen they get the 3R letter? Here are your options. You're still receiving workers' comp, but you've been out of work for almost a year. Here are your options. You can return, you can resign, or you can retire. You've been there 18, 19, 20 years plus. Now here are your options. Get out or sign out or pension out. Which is oh, right. So again, remember, for the question is, what about the 4 week things? That's just there if you're still receiving treatment and you're still out of work. If the doctor releases you in New Jersey, once the doctor releases you from medical treatment, and they say you've reached your maximum medical improvement, then that temporary disability from workers' comp stops, because in theory, you've gotten well enough that you can return to work. Okay, so workers' compensation doesn't have to make you 100% like you were before you got hurt, but they have to put you back together enough so that you can actually return to doing your job. Oh, good question. Somebody's asking a question about an FCE. I will get to that in a few minutes, because that I will go on a flying rant on functional capacity. So let's talk about some more of these out of work issues. So again, you're going to see discipline issues, the FMLA issues, and the 1 year issue, which then calls into play that return, resign, retire, the 3R letter. If somebody is out of work for more than a year, then there should be a conversation starting to happen about the possibility of applying for Social Security disability. So just so that everybody knows, if you are out of work for more than 1 year, then you are eligible to receive Social Security disability benefits. But if you, let's say, 6 months later are able to return to work, Social Security says that you're eligible for what they call a closed period of time from point A to point B. All right. And that's money on top of what workers' comp had paid you. So if you're only receiving 70% from workers' comp and you're out for that period of time, as long as that period is greater than 1 year, then you're eligible to receive additional benefits from Social Security for that closed period of time. So we go through the process and help somebody get those benefits as well. And again, if it starts to look like after a year that someone may not be able to return to work, then we're also going to start wanting to talk about disability pension options. So when somebody is receiving medical treatment, no one ever will tell you that you have to accept medical treatment that's being recommended. There's a legal consequence to not doing that, and I'll explain that in a second. But nobody requires, like if the doctor says to you, I think at this point, the only thing left is surgery. And you say, well, I don't want surgery. So that's fine. But so that you understand what would happen, they're making a recommendation for treatment. You have chosen not to accept that treatment, totally fine. But then what happens mechanically is that that temporary disability from workers' comp would stop. Because the doctor says, well, you've reached your maximum medical improvement. There's nothing more I can do for you other than surgery. So therefore, you're at your MMI, workers' comp stops, and now you're left with, wait a minute, what's going to happen, right? So the FCE, or what's called the functional capacity exam, comes into play when these kinds of things are happening. Either you're getting close to ending treatment and you're not really doing as well, and the doctor's like, well, I don't know, you've had 6 weeks of physical therapy, and the adjuster's yelling at me because I can't give you 6 more weeks of physical therapy because God forbid, right? So I know what we'll do. You'll go do a functional capacity exam. Now, I will tell you this. If somebody wants to or feels like they can go back to work, we will refuse them doing the functional capacity exam, and you have every right to do that because a functional capacity exam is not medical treatment. It is not a diagnostic study like an MRI or an X-ray or an EMG. It is a tool that is used not as the doctors want to couch it like, oh, let's just see how you're doing. No. That is not what happens. That FCE is used as an absolute sword to get people fired or require them to apply for their disability pensions. That's what it's there for, okay? What happens is you go and take this functional capacity exam, and it comes back and it says, oh, well, you know, you did pretty well, but you have this permanent restriction. You can only lift up to 40 pounds, but that's a permanent restriction. And they write that right in the thing. Now, you may still be able to do your job with a 40-pound weight restriction, but it's a permanent restriction. So the employer hooks right onto that and says, oh, sorry, you've got a permanent restriction. Can't come back to work. Here are your options. You can resign or you can retire. Now, if somebody has gotten hurt or their injuries are going to prevent them from going back to work. So let's take, somebody who does a lot of patient contact, somebody at Trenton Psychiatric Hospital or Vineland Developmental Center or something like that, where there's a ton of patient contact, where you're gonna have to lift and push and pull and all those things. And based on your injuries, you're not going to be able to go back and do that. Then yes, I want them to go and do a functional capacity exam because it's going to say that you have permanent restrictions, and it makes the pension application easier because the employer has now just said, we can't take you back. So, but you got to be careful with the FCEs. And this is where you got to know it, and you got to just tell people, because as I've said, that functional capacity exam, more often than not, is used in a way not to get a measure of how you're doing, but it's really used in a way that will undercut somebody's ability to return to work. All right. So that's sort of the FCE. Okay. Here's one. What happens if HR tries to discipline you for using more sick time when you return to work? Well, your sick time is your sick time. You have the ability to use your time, despite what HR may think. So certainly, if you have time and they tried to discipline you for using your time, that's certainly something that we do locally. I'll do that all the time. I go to Trenton. How many times have I done that? Ann Klein, Trenton Psychiatric Hospital. What I call the nonsense, the HR nonsense. And here's the other thing. Here's one of my favorite phrases, and I say favorite phrase because I use, if you can see the dripping sarcasm when I say favorite phrase, is, well, that's the way we've done things. Well, that's just great. That's completely wrong, but it's great that that's the way you've done things, okay? So when you hear HR say, well, that's the way we do it, that's great, but that's not the law. That's not the way it's done. And so we're going to either change it or we're going to start butting heads, okay? So you got to be aware that they don't know anything or very little. I don't want to say anything. I don't want to, and it's not everybody. I'm painting with a big brush, obviously, but for the most part, I would refer it to as it's the person who thinks they're the big fish in the little pond and it's their little world, and you're going to play in my world or I'm going to make your life a living hell. Okay. I mean, that's what happens. And so, it's I joke, there are times where I get invited to do these kinds of presentations to rooms of adjusters and insurance people. And I wear the black hat because, boo, petitioner's attorney. And one of the first things I'll do whenever I do those things is I'll stand up there and I thank everybody in the room. And I tell them I want to just thank them because if they were to do the right thing, I wouldn't have half as many clients as I currently have. So I tell them to keep up the good work. And it usually gets the right amount of chuckle, but the reality is I'm saying it for a reason, because it's true. The way in which that most of these people handle these cases is ridiculous, okay? If you think about it, if the amount of time spent trying to deny someone the basic rights that they're entitled to through workers' compensation, if that energy were focused on getting you to a real doctor right away and getting real medical treatment, then people wouldn't contact me. Pay the bills. If I get a bill and I give it to my HR and they pay the bill, I'm not going to complain about it. One of the greatest stories I had a client who worked for somebody for over 25 years, and she had carpal tunnel surgery. They paid for it, the whole 9 yards. She got a $50 medical bill. I'll never forget this. $50 medical bill. She turns it in once. She turns it in twice. 3 times. Finally, she gets a collection notice. So she comes to my office and she shows me the collection notice, and then we start talking and whatnot. And she says, I don't want to sue my employer. I love my job. I don't want any trouble. And I assure her nothing bad is going to happen. Just let me do what I do. So needless to say, we got the $50 medical bill paid, and I got her another $10,000 for her injury. Now, had they paid the $50 medical bill, she never would have come to the lawyer. I never would have done that, and they would have saved their $10,000. But it's, what's the phrase? Penny wise, pound foolish kind of thing. And that's what they do. That's what they do. So, anyways, so sort of a side rant a little bit, but so we've got all these things floating around, but when you get to the point where you are released back to work, I've gotten hurt, I'm better, I go back to work. Yeah, somebody just asked a question. What do you do when the adjuster tells you that you're not the only person, that she has several folders for other people? Yeah, so the answer is you contact me and we'll file a motion and I'll get in front of a judge and we'll bang them over the head. That's the answer, right? Yeah, the same nonsense, Michigan. So when you're all done, now we're going to move forward. Now we're going to move forward to try and get you an award. So let's talk for a few minutes about what that actually means. So work-related injuries, when it comes time to figuring out, let's say, a value of an injury, I'm going to do it this way. Mechanically, when you're done treating, we get all the medical records. I'm going to send you to a doctor. The other side's going to send you to a doctor. These are evaluations for purposes of trying to settle a case. Okay. So let's go with our knee case again. And let's say in my knee case, because I fell and hurt my knee, I needed knee surgery. So we had a scope in there, did the therapy. Now I'm back to work. Okay. My doctor is going to say that my percentage of disability for the leg, because the knee is considered a leg in workers' comp, is 50% disability. Okay. And then the insurance company doctor, he's going to look at everything and he's going to say, oh, no, it's 5%. And that's typical. That sort of wide range in terms of those percentages is very typical. And so, again, the attorneys that do this know that if somebody has a surgery on their knee, the value of that case roughly is going to be somewhere between 20 and 25% of disability of the leg. Now, what does that mean, right? So let's break that down a little bit. Okay, first things first. What you should know is that every body part is covered on a chart. There literally is a chart that has across the top of the chart body parts. So there's a column for the hand, arm, thumb, fingers, leg, foot, so on and so forth. All goes across the top of the chart. Down the side of the chart are percentages of disability. 2.5, 5, 7.5, 10, all the way down to 100. So you say, okay, this is a leg case. You find the leg column. You go down to 22.5%, and you go like this. They cross, and there's a little box on this chart, and inside the box is money. So when I go to or I conference workers' compensation cases, we never talk about money in the sense of dollars and cents. It's always done in terms of a percentage of disability. Now, we know the higher the percentage, the greater the dollar, but the conversations and the negotiations are always in terms of, I want 20%, I want 30% of disability. Now, the language, this percent of disability, that percent of disability, permanent disability, that language has a meaning inside the bubble world of workers' compensation. 25% of disability of the leg means you get X dollars. That's what it means. It doesn't mean that you're 75% good and you can only do things to 75%. It doesn't mean that you can only do your job to 75%. It just means that in the land of workers' compensation, this 25% disability of your leg equals, $18,000, whatever it equals, and that's the award. So when it comes time to figuring out the value of cases, that's how it's based. It's based on the evaluations. It's based on the treatment that you receive. It's based on what your job is, how well or how much do you struggle now that you're back at work. There are a lot of factors that go into it, but at the end of the day, the negotiations in terms of what's the value of a case, it's based on this chart, and it's based on the evaluations, and it's based on the other aspects of the case. Okay, so that's how the cases are valued. All right. Now, so that is as it relates to the awards. Okay. Now, one of the big things that we've all faced over the last couple of years has been COVID, right? And COVID, depending on if you've gotten it and when you got it, has automatically or should have automatically been covered by workers' compensation, because there were governor's orders that were the executive orders that indicated that if you were essential personnel and then you got it, the presumption was that it happened as a result of the work exposure. Now, we're coming out of that, but again, depending on when you have gotten COVID, the other side is actually forced to prove that it didn't happen at work, and that's impossible. So workers' comp would be responsible to provide the benefits, and a lot of the times it didn't happen, right? They would say, use your time, or there was like, what was it, at one point it was like 6 months, we'll pay a COVID pay, they called it. But I had plenty of clients who they were just grabbing their sick or vacation time. They didn't know what the heck to do. And then now they've lost, weeks, months of sick or vacation time. If somebody was exposed and 5 days later they're back at work because they have no problems, then yeah, it's covered by workers' comp, but there's no injury. There's no way I can get somebody money for that. But if they were on a respirator and somebody now is having, let's say, heart problems, or what they call the long-term COVID effects, fog brain, the concentration issues, the heart issues, all of which medically is developing. But what we see is that those things are all happening because of the exposure to COVID. And those are all things that you should know should be covered by workers' compensation. So those are, and again, the benefits that we've been talking about are those that should be provided as a result of that exposure to COVID. And again, workers' comp are going to continue to try and deny those cases because they don't want to deal with it. But the reality is that like the slip and fall, the exposure to COVID at work is real, continues to be real. Excuse me, continues to be real. And certainly if that were to happen, that would be something that should be covered by workers' compensation. So I see Steve is back. I don't know if that means I'm getting a hook or he's just
No, keep going. Keep going. You're doing fine. I do
Okay.
have a question I want to ask the group before we break for the night too. But I did have one side thing that you had mentioned in the beginning when you talked about the two different types of workers' comp, and you referenced as an example carpal tunnel, right?
Yep.
What about somebody who works in public works and has been a sanitation worker or is in recycling and is getting on and off the truck, right?
Sure.
Lifting heavy cans.
Sure.
And they develop, rotator cuff injuries or knee injuries. Is that a type of long-term
Absolutely.
comp?
Absolutely. The same kind of repetitive action. Somebody who jackhammers, right? They usually wind up getting issues with their elbows because of the constant vibration that comes from the jackhammer. Those are the over periods of time. Absolutely. On and off the truck, on and off the truck, on and off the truck. The repetitive throwing like this, there goes the shoulder. Absolutely. Those are exactly the kinds of occupational claims that we can pursue. 100%. Jennifer asked, do you need a lawyer to get an award? The answer is yes. Workers' comp, you can do basically everything, but in order to receive an award for your injury, you need an attorney under the statute. The judge cannot award money unless you're represented by a lawyer. Phyllis asked a great question in terms of pre-existing. So here's one of my favorite things, right? In workers' compensation in the state of New Jersey, if you have a pre-existing condition, but you get hurt at work and the work accident, here comes the magic language, aggravates, accelerates, or exacerbates the pre-existing condition, then it's covered by workers' compensation. So the insurance company will be like, oh, you hurt yourself before. Oh, it's related to that, not this. The doctors will say, oh, this is degeneration. This has got nothing to do with your work accident, right? All of which is nonsense. If you can demonstrate that the work accident aggravates, accelerates, or exacerbates the pre-existing condition, then it is absolutely covered by workers' comp. Now, here's the best part. When we were talking about these percentages of disability, right? The higher the percentage, the greater the dollar. So if you have a prior disability, let's say you've injured your knee before and you had surgery before. Well, okay. So instead of starting at 0 and going from 0 to 20% or 0 to 25%, now you actually start at maybe 15 or 20% and you go up from there. Now because there's a pre-existing condition. Now the insurance company gets a credit for the prior issue, but it doesn't matter. The reason it doesn't matter is because now you're going higher and higher on that scale. So the overall dollar is going to be greater. So if they really want to push it, that's fine. I'm thrilled. Let's get all the pre-existing records in there. Because to me, the higher the percentage, the greater the dollar, the more I can get from my client. So if there are pre-existing problems, unlike like where in personal injury matters, car accidents, slip and falls, where prior issues really, can affect how much money you might be able to get or whether or not you can win in a personal injury case. In workers' comp, doesn't matter. If I can show that the work accident makes it worse, we're in business. And the fact that you've got prior issues, I want to go get all those records because I want it to go as high as possible. And if I show that there's a big pre-existing and now we have a new work accident on top of that, well, now the overall percentage is going to be that much higher, so we can get that much more money for our client. Can you answer Supervisor back? No, yeah, I wish. Good question. Question is, can you sue your employer? The answer is no. You get hurt at work. There's a section of the workers' compensation statute which specifically says that I cannot sue the employer for the work-related injury. So now that's not to say that if my job is to, let's say, drive from A to B, and while I'm driving from A to B, I get hit from behind by another car, not somebody at my job. Well, not only do I have a workers' compensation case because I was doing my job driving from A to B, but I also have what's called a third party case or a personal injury lawsuit against the person that hit me. That you can pursue, and you can pursue both cases. But in terms of if a coworker or you're in the parking lot and somebody pulls out and hits you, it's a coworker, then you can't sue the coworker because it would be covered by workers' compensation. So good question. I can keep going, but I don't know what everybody's timeline is or how you want to do it, Steve. You tell me.
How about we do, if you have the time, Sam, how about we do about another 15 and then we'll wrap up?
Sure, perfect.
Does that give you enough
Great.
time?
Yeah, plenty of time. I like I said, I love this stuff. Are you kidding me? I can keep going. So, so we've been talking about workers' comp, and I said earlier too that once the case settles and you receive your award, now you're going to have a window of time. So you settle your knee case, it's 25% of the knee. A year later, your knee is bothering you. Now you want to try and get more treatment. So we have to reopen the case. And as long as we do that, within that 2-year window from when you receive your award, you now have 2 years in which you can reopen your case. And it's like hitting the redo button in an old video game. You get to start all over again. They have to send you back to the doctor. If the doctor said you had to be out of work again, then they're going to have to pay you again. And then if the disability gets worse, then we're going to have an increase in the disability. So you're entitled to receive more money for your injury. And again, do it again and do it again. And actually, a good story is that a couple of years ago, I had we had a contractor who had hurt his knee. And so we went through the process and then we settled the case, and then he needed another scope. So we reopened, closed, open, closed. And it was 10 years later where we got the workers' comp insurance company to pay for the knee replacement that he now needed as a result of the progression of the worsening of that knee. So you can reopen and close and reopen and close as many times. There's no end to the number of times that you can actually do that. As long as you can keep showing that the disability is because of the work accident, then you're in business, and there's no limitation on the number of times that you can actually reopen. Okay. So that's on the reopener. And typically what happens is we try and get people back to the same doctor, because that way there can be an apples to apples comparison as to, oh, I saw you 3 years ago, now I'm seeing you now. And so as a result, oh yes, it's definitely gotten worse. This is what we need to do. So that's that. So that's on the reopeners. Okay. So the other thing now is this, and I'm going to touch on this a little bit. And certainly we can do, if Steve wants me to come back and can do a whole presentation on pensions as well. But what I'm going to tell you is this: if somebody is in a position where you are going to apply for a disability pension, like workers' comp, like we've been talking about, it's so niche, and you make a left-hand turn and you could be in, in a wrong patch, right? Same with pensions. And I'll give you an example, and I see it all the time, and it kills me because I do a lot of cleaning up of spilled milk, if you will. All right. And sometimes it's very, very difficult. When you apply, if you decide you're going to apply for a pension, there are specific requirements depending on what kind of pension you're going to apply for. And basically, there are two types of disability pensions. There's an accidental, there's an ordinary. And the easiest way to think about it is this: accidental are for work-related injuries, ordinary disability are for non-work-related injuries. Now, that's a really big picture because they can be both, but just for our discussion real quick, accidental is work-related, ordinary is not. But when you're applying for an accidental disability pension, you have to be very specific about how you got hurt, how you got injured, the way in which you describe those things, because it matters when somebody looks at it. So if you have 3 things that bother you, and 2 are related to the work accident, the 3rd is not, and you include them all because some nice person at pension says, oh, well, the more you include, the easier it is. Now they're going to look at it and say, oh, well, wait a minute, this 3rd thing is not related to this, so therefore that's why you're disabled, so you're not entitled to the accidental. And there's so many tiny little ways that between pensions, the pension boards, that they can try and maneuver, I'll say maneuver, not manipulate, but maneuver through to their advantage. You gotta just be very, very careful. So the long and short of it is if you have someone, or if you're in a position where pensions or disability pensions are starting to become an issue, where like, I think this might have to happen, I invite you to, my information is here. It's in the presentation. Steve has all of my information. Everyone has access. I'm going to give everybody my cell phone. If you feel that you have a question, I say this all the time, please, please, please. I'd rather take 10 minutes and answer some questions so that you know exactly the language you need to use than to see you wind up in a situation where you really get screwed. And let me just show you the difference. If you're in PERS, public employees, and you apply for an accidental disability pension, if you get that, that's going to be 72.3% of the average of the highest 3 years of salary, tax-free, plus your health insurance. If you get denied accidental and you only get ordinary, that is only 46.3%. Those are taxable dollars. Yes, your health insurance comes, but they make you pay 1.5%. Okay. And the dollar differential between those two, if you just think of the math, just the taxes on that alone are enough to choke a horse. So, and it's because of language, because of the way in which you write something or the way in which it's categorized. It's just brutal. And I feel horrible for those people who don't or haven't. And what they'll say, here's the answer, honest to God, is they'll say, well, the counselor told me that's what I should include. And it's not, in my opinion, it is not that they are trying to screw somebody. It is that they are giving information that's of a broad base. And it's like in the most times, this is the right answer. But in this particular case, it wasn't. And they're giving out the wrong information. Not intentionally.
Sam, I just want to interject there just for 1 second. I don't want to mean to disrupt your flow. I know
no,
we have
not at all.
questions from Phyllis and from Jamie in the chat for you to get to. But there are 2 things that I wanted to do, and I want to make everybody aware so you don't miss this. I'm going to type in the chat box now. I want to get your feedback. Who thinks we should have Sam back to do a separate seminar for our members just about pension disability and or Social Security disability? Okay, so if you think we should do that, type your thoughts in the chat box and we'll do, we'll take that feedback back. But the other thing that, when Sam was talking about people who are trying to be helpful and too much information, if you have ever testified at an arbitration or a court case, if you're being represented by a good attorney, they will tell you, listen to the question and answer the question that you are asked. Do not volunteer information. Do not go beyond what the scope of the question is, because every word that you say is a potential gift to the opposing side. And in this particular case, with whether it's, with workers' comp or the pension disability, the more information you give beyond what is required and what is necessary is a potential gift. And that's why I think one of the questions in there, Sam, which you'll see, and I was going to wrap up with this, but I might as well say it right now. Look, you should consult with an attorney. You should tell members to consult with a workers' comp attorney for the very reasons that Sam mentioned. If you have a heart problem, you don't go to the podiatrist, you go to the cardiologist because it's a specialty. But always assume that the employer and the insurance company are looking to screw you. There's no other way to put it. So, Sam may have a different take on it. Others may have a different take on it. In my opinion, if you're hurt at work, you should consult with an attorney, with a workers' comp attorney. That's just my 2 cents. But go ahead, Sam. I kind of hopped in there.
No, listen, I couldn't agree more. I mean, and again, be it myself or someone else, but the answer really is that you got to make sure that if you're talking to somebody, that they do this. It's not like, oh, I do matrimonial, I do wills and estates, I do workers' comp, I do personal injury, right? You don't know what that lawyer does, right? As I said earlier, it's a club. The attorneys that do this, that really do this, know every lawyer that really does this. And when somebody new shows up, everybody's like, who's that person? And everybody knows it, right? So I couldn't agree more. So the only other thing I do want to say is that at the last page of the presentation of the PowerPoint, which was sent out, is all of my contact information. My cell phone is there, my email, our website. So if you have any questions, you can reach me at any of those access points. Just reference, or if you send me an email, just say AFSCME, so I know that you're a union member, and more than happy to spend time talking. My cell phone is always available, always with me, always available. And then if you're interested, I do a little presentation, not as in-depth as this, but every Saturday morning at 9 o'clock, Facebook Live, Saturday with Sam, on the Schaeferman Facebook, Schaeferman Lake and the law firm on their Facebook page. So every Saturday morning, 9 a.m., we pick a topic. I answer questions just like we've done tonight, and we give a little presentation, 15, 20 minutes. So always there. My feeling has always been that the more information that you have up front, the more knowledge that you have about all of these different systems, the more empowered you're going to be, and the better off you can help other union members and basically help yourselves against, as Steve put it accurately, an industry that is looking to screw the injured worker.
Yep.
That's it.
For sure. Sam, I do just want to get to Jamie's question, and I know you've been getting to him, but when I asked about whether we should have you back for the pension disability, people were responding, and I don't want Jamie's question to get lost in the shuffle. Sure. She said if someone had contracted COVID at work, they used COVID time, but now a year later, they're having long-term problems. Can they get workers' comp?
Yeah, actually 100%. So, first of all, if it's only a year, you're still within a 2-year statute of limitations anyways. But even if it were longer than that 2-year window, the statute, the workers' comp statute specifically says that you have 2 years from the day that you knew or should know that you have a condition and the condition is related to the work exposure. So the example, the really great example that sort of outlines that is, if 25 years ago I was exposed to asbestos and now 25 years later I have mesothelioma, my statute of limitations to pursue a claim is 2 years from the day that the doctor diagnosed me as having the mesothelioma. So if someone a year and a half ago, 3 years, well, where are we, 2022, right? So, yeah, so we're still within 2 years, but let's say somebody is beyond that or goes beyond that 2 years, and now the doctor is diagnosing you as having a heart condition. And the doctor says, well, yeah, the heart condition you now have is absolutely related to your exposure to COVID 3 years ago. Well, click, now that starts your 2-year window to pursue a workers' compensation case. So, yes, very much so.
All right. Does anybody have any additional questions for Sam? Again, we'll have him back in early 2023, and I think we're gonna talk with Sam and the Education Committee about setting up a separate seminar just on the disability, the pension disability and Social Security disability, because those are a whole other world as well.
Yep.
So Phyllis, the PowerPoint presentation we sent out to everybody before we started, we're going to send it out again tomorrow along with the recording of this. If you did not receive it, please put your email address in the chat now or send it through a direct message to me in the chat, and we'll make sure that you're included on the email list. Okay.
Cool. Well, listen, I want to say thank you. I appreciate the opportunity this evening to come and speak to everybody. I certainly hope that everybody got something from the presentation, certainly. Again, I'm happy to answer any questions. If you think tomorrow, oh, I should have asked this, don't hesitate to reach out. I really do mean that. I'm here to help you. And I just want to say thank you to Steve and everybody at AFSCME for just allowing me the opportunity to come and speak to everybody tonight.
Well, we appreciate it, Sam. We appreciate you taking the time to talk with our members, and certainly for our members through the years. I think I don't want to reveal our age, but we could probably say decades now, plural,
Yeah, close.
with representing our members. So, yes. All right. Well, thanks so much. We'll send out the follow-up information. We'll have Sam back for the disability. We will send the recording along with the PowerPoint, and of course the PowerPoint will have Sam's contact information on it. And as he had just said to you, if you have a question, you reach out to him, and don't forget Saturdays with Sam, 9 a.m.
9 a.m.
9 a.m. on Facebook.
Yep.
Okay. Thanks, everybody.
Thank
have
you.
A good night.
You too. Bye-bye.
Good night.